What you're about to experience is one man's quest to see beyond the tumultuous period we're in and to envision what lies just beyond our grasp, yet well within our reach. Welcome to Larry Rifkin's America Trends, where the future has arrived, and it's just in time.
Welcome back to America Trends, Larry Rifkin and John Krofsik. And John, you and I have some firsthand experience about the topic that we're dealing with today, and it's called the jury crisis. But you and I, we've gone to sit on petite little juries, haven't we?
Yeah, well, I think it's my duty because the way I look at it is if I ever need a jury to decide my fate, I want it to be people who really want to be there, hopefully, and will listen and...
But, John, you have no peer. There is no one. You are peerless. You are fearless and peerless. Well, I got selected at least to be in a pool because I vote too much. I vote in every primary. I vote in every election. Yep. And so I'm on the list. But I've got to tell you, several years ago, there was a judge that I ran into at a party, and he said to me, "You're getting called too much." We just started talking about this. And he said, "Look, this is what you do. You look for one delay and make that delay the last Friday in August because there's never court
You're
on the
giving your
last
secret away.
I know. Well, forget it. Well, actually, it didn't work one time. And I ended up going. And it was interesting because at the time I was head of programming for public television in our state. And they said, "You do a lot," when they were doing voir dire. And they said, "You do a lot about the criminal justice system, don't you?" And I said, "Yeah, we do. We do a lot of reporting on it." So they couldn't quite figure me out. So I love what they do. Then they send you in the back.
Right.
And they say, "We're going to deliberate about you and whether we want you on the jury." And I came back and I almost thought I was on trial. You really do.
No, it's scary.
No, it's a very formalized process. And they said, "Mr. Rifkin, you have not been selected." And I was so glad because I saw this guy who had been indicted for murder staring at me.
I know it's a scary process.
It really is.
They're a lawyer and them, and you got it is.
But I had another incident where I was going to be on a civil jury for a civil case. And my wife had been a small business owner. And so I did say, look, I have a little bit of a problem because my wife thinks some of the laws in our state are stacked against the small business owner. So I came back and they all kind of knew me because we live public lives in our state. And the judge said, "Look, Larry, you tell me, is this the right case for you?" And I couldn't believe he was asking me. And I said, "Judge, I don't know if I can be fully impartial because my wife has shared some concerns that she's had." So we've all had our situations. Right. But I'll tell you, now that I'm kind of peri-retired, I'd love to sit on a jury. I really would. And go all the way.
Yeah.
But the problem is, John, nobody does that anymore because when you look at the number of cases and how many get settled in arbitration, mediation, settlements made just when a jury has been picked, we rarely do go to trial.
I think picking the jury is just done to scare people and then they
settle up.
Negotiate.
Yeah. And plea bargains. Let's be honest, our system would collapse under the weight of jury trials. We just can't handle it all.
Right.
So either we have too many laws and we find too many things that are out of bounds in terms of legality, or we've got to figure out another way because I don't know that anything we're really doing with the jury system is necessarily working. And maybe I got that perspective from reading this book that we're going to be talking about today. And I found this topic fascinating. I find most of the things we do fascinating, but this one really got to me. And the gentleman that we had, Drury Sherrod, and he runs one of these companies that helps to mock trial things and test whether a company is going to go into court and get lathered for multi-million-dollar settlements. And so he can tell them, like Bull, which is a series on television now. Haven't watched it, but I've read about it. And these court cases can be told in advance, you're not going to win. Nobody is sympathetic to what it is you're selling you.
I mean, nobody's sympathetic to large corporations anyhow.
Right,
'cause
exactly.
You feel they're robbing you. So
Exactly. So just make a settlement. Do it quietly. Don't end up in the press all day, and you're going to get your head and your checkbook handed to you. So, but this is really fascinating because I don't think any of us have ever seen a deliberation. We've seen dramatizations of what really goes on behind the scenes as the jury is deliberating. We talk about a fascinating range of topics related to juries, and I enjoyed every minute of this, John. I really did.
Yeah, it's good. It's a good topic because nobody ever talks about juries.
No, and it's such an important part of our system.
It is.
My goodness.
We need good people to serve on juries.
Well, let's talk about the jury crisis. And by the way, that doesn't mean that if you decide to go to trial and you've got 3 judges, that you're doing that much better. So we'll talk about that too. The jury crisis. What's wrong with jury trials and how we can save them today on America Trends. With us on the line is Dr. Drury Sherrod, and we can call him Drew for the rest of the interview, which is great. He's written an incredible book called The Jury Crisis: What's Wrong with Jury Trials and How We Can Save Them. And I think many of us think about the jury system as being really almost infallible. There's something wonderful about it, almost mystical. But I don't think we often think about how unique it is and the ability to get 12 people, particularly in this fractured moment in American history, to agree on just about anything.
Yeah, one of the solutions is to cast the net wider to generate jurors, to make sure that more people get their jury summons. For example, poor people don't tend to get summons. They don't tend to show up because they move often, the addresses are changed, their employer won't compensate them for taking time off and doing a jury trial. Rich people just ignore it and hope they can get by not showing up. Some states actually have all this tied into to a traffic stop. So if you got stopped for a traffic violation, the policeman might say, "And I see that you haven't shown up for your last 3 jury summons. We could arrest you for that." So it's very hard to actually achieve a jury of one's peers. And a lot of the issues are sort of beyond the scope of my book. They have to do with education, income equality, class differences. So that's beyond. What my book focuses on is a way to make jury trials themselves more respectful of the human brain so that juries will not be as ridiculed and demeaned and denigrated as they are.
Well, yesterday, there was a unanimous verdict in the case of El Chapo. And I'm just wondering how you looked at that, because it was on many different counts, and it wasn't a mistrial by any means, and it seems like they really did throw the book at him. What did that trial say to you about the jury system, if anything?
I'm glad that it turned out the way it did. I've read about it, and there was 3 months of testimony. That was the prosecution. Then no defense was put on. So after 3 months of testimony, then the judge instructed jurors on the jury instructions for 3 hours. And if you're even a 5-minute version of judge's instructions will make your eyes roll. It's so arcane. So I can't imagine jurors sitting through 3 hours. And then they had to reach, 10 counts, 27 subcounts, an 8-page verdict page with 54 separate verdict questions. So I doubt that these jurors will be interviewed after the fact for the sake of security. But what I would like to know is, did they really consider carefully 54 different verdict forms? They might have, because they deliberated for, 5, 6, 7 days, 6.5 days. This jury did a good job, I think. But I would like to know, did they just reach a general decision that he's guilty on, say, all the charges of drug trafficking, so we'll just check all these boxes off? Or did they really deliberate each of the 54 boxes carefully?
Well, let's get into what your book suggests. First of all, you say the jurors seldom obey a judge's instructions to keep an open mind until they've heard all the evidence. How do we know that?
Lots of ways. First, there are we've run lots of mock trials where we give jurors specific instructions, the mock jurors, before they retire to deliberate. They just almost completely ignore the instructions and ignore the law. There's so much psychological research that jurors actually, as soon as they start hearing anything about the case, they begin telling themselves a simple story that then guides how they attend to the evidence during the 6 weeks or 6 days of trial. It determines that they basically look for and remember evidence that supports their positions and don't pay much attention and don't recall evidence that opposes their positions. So basically, jurors manage to convert the complicated evidence into a simple narrative. And that's where part of the jury crisis is. The jurors are seemingly so demeaned, so ridiculed, But in fact, it's actually that we're asking too much of the brain. We're putting jurors in a situation where they basically can't perform very well.
Well, you remind us that the way they're getting information is fragmentized generally. They're not hearing a story, if you will, and that's how we do process a lot of information. So how is it that you would like to see lawyers approaching what is going on during a trial to help these jurors do a better job?
Now, the simple version is for judges and lawyers to think like jurors instead of like law school professors, to realize that the human brain works pretty well for the first 800 years of trial by jury. But then most of the last 100 years, as trials got more and more complicated, there was just too much information for jurors to process. And the book by Daniel Kahneman on Thinking Fast and Slow makes a really strong case that the brain evolved to tell stories, quick, intuitive, instinctual stories, not to do slow, rational, analytical evaluation of evidence. So we just can't help it. The brain we have has evolved to tell stories. So early in a trial, jurors find a story that helps them understand the case and then fit evidence into that. So if that's what jurors are doing, it only makes sense for the judges and lawyers to be respectful of the human brain and mimic this storytelling capacity. So when you're selecting jurors, you're selecting storytellers. When you're presenting information, you present it as stories that organize the evidence. When jurors deliberate, they deliberate as storytellers, and different jurors have different stories, and they try to hammer out a single story.
Now, let me ask you, and when some of these cases ultimately go to appeal, and many cases do go to appeal, is the fact that jurors probably are making their determinations early on in the process. They're not processing all the information, all the intricacies of what goes on. Does that make it easier to overturn their decisions?
It may, but then the problem is you just find another group of biased information processors. There's so much research on appellate court judges. Appellate court judges serve in panels of 3, and they're randomly selected from the courts in the district. And that means there can be 3 Republicans or 3 Democrats, or say 1 Republican, 1 Democrat, whatever. It turns out that if it's 3 at the same party, for example, 3 Republicans arrive at much more conservative decisions than if only 1 Republican had been in the panel. If 3 Democrats arrive at much more liberal decisions. So there it seems that appellate court judges are pretty much like regular jurors. They suffer peer pressure and informational overload and just cave in to their fellow judges.
Really interesting, because we think of all these folks as somehow gaining this incredible amount of wisdom when they become jurors, that all of a sudden they understand arcane elements of law, but they don't. They don't.
They don't at all. One little sort of cute anecdote I like, we also have been hired to run mock judge trials, just like a jury trial, but the actual trial will go before a judge, so the client wants to know how will judges view this. So we'll hire, say, 10 or 12 retired judges, and they read dense packets of information. Then they deliberate for a day, and then we ask them to fill out a questionnaire. These judges can split 6 to 6, just like jurors. And within one category of the 6, it may be, say, it's a class action lawsuit, and how do you determine a class? There may be 4 different ways of determining a class. So the overall split is no class action or a class, and then various subclasses. And then some of the explanations judges will give are just kind of common sense explanations. Judges function like jurors, just with somewhat different biases.
Interesting. I know in the case that Bob Mueller is looking at as we record this, we are told that he does what are called speaking indictments, prosecutor as a storyteller. Is that what you read when you read a Mueller indictment?
I'll have to say I haven't read a Mueller indictment.
Okay. But when you hear the term speaking indictment, is that what it suggests to you?
Well, I hope they're telling stories. I mean, I'm hearing for the first time from you that in these speaking indictments, lawyers are telling stories. Is that what you're saying?
Yeah, absolutely. And trying to explain what it is that he's trying to put together, if in fact there is a conspiracy or if there are just players working in tandem one with the other. And it makes it a very good and more lucid read than some of the other legal texts others might put together.
Well, if he's doing that, I admire it. Normally, when we do mock jury trials, we will sometimes have the attorneys write their case, and we write a case opposing them. So they will. We view it as their yellow pad approach. They'll have a yellow pad of, say, 50 items. They'll just dump each item on the jury and check it off, and it's out of chronological order or out of narrative order. and then we write a narrative opening statement, which would have 5 themes, beginning, middle, end, moral closure, and it organizes the evidence into each narrative, so that when a juror deliberates, what they really have to recall is the overall story, and then they can fit the evidence into that story. And then we also train witnesses to find out their role in the story, so the witness doesn't just fly in when it's convenient. They fly in when their element of the story is ready to be presented to jurors, and they also tell their story.
Does the standard beyond a reasonable doubt hold the same meaning to all jurors, or how difficult even is that notion to describe or explain in terms of their duty to a jury?
Reasonable doubt is one of those issues like, what is the truth? Are all the truths relative? What's reasonable differs across educational levels and income and class and how we appraise risk. For example, standard of ordinary care or reasonably safe testing. The answers to those questions differ by how you appraise risk. And the example I sometimes give is, for example, old rich white guys can protect themselves pretty well. The world doesn't hurt them. They take care of themselves. And a young poor minority woman, almost everything out there will roll over her, and so she's wary in advance. And so she would apply probably a different standard of risk or care than, say, the old rich white guy would.
You walk us through one case in particular, the Dewey and LeBouf white-collar case, as what can go wrong. Give us a quick synopsis of that case to help illustrate some of the points that you're making.
That case lasted for, I think, several weeks, and then the deliberations were quite protracted. And then the jurors, it became a mistrial, a hung jury. They just couldn't decide. They barely could figure out what their role was. I think it was all about whether or not senior partners had defrauded a law firm, and there were just scores and scores of emails and computer pages and economic projections that were just far beyond the jurors' heads. And I think I used that as an example of everything that could go wrong did go wrong, because the information was presented far too densely for people to understand it. Then they couldn't recall it. They couldn't fit it into what the judge told them their job was. There was finally too much to even remember. There were 2 or 3 main charges, and then dozens and dozens and dozens of subcharges. And the brain doesn't function that way.
So is this going on as we have built all of this case law and all of these precedents, that the law continues to get thicker and denser, and we as people don't really know how to even begin to process the technicalities of this law? I mean, we didn't go to law school.
Yeah, I would say that's what's happening. Also, if you look at history of the jury, originally the jurors just told stories. They were assembled by some officer of a king who would ride into town and collect some local villagers who were all men of the same sort of social stature, and they would spend about half an hour discussing the likelihood of the accused having done something blameworthy or not, and then reach a verdict. And it was more like a gossip session with a bunch of guys sitting around talking about different people in the village and who might have performed a criminal act or not.
Well, we never really get to see what goes on in terms of deliberations. Now, in certain cases, we have seen it dramatized in 12 Angry Men, where Henry Fonda was able to turn the entire jury by really having them slow down and think about this more rationally. Then, of course, in To Kill a Mockingbird, where it was almost fait accompli that this poor black man was going to be accused, and he was also going to be convicted. But with that, we never see the actual deliberations. And your book reminds us that there are no transcripts. There's really nothing that we can go back to figure out what went on in there. So you, I know, have a bird's eye on this, given your consulting firm. What does go on in these deliberation sessions?
I've done a lot of these. I've done many, many, many post-trial jury interviews. And after a trial, about half the people really want to ventilate, justify, explain. Half the people just will say, I've done that, I'm over it. I gave 3 weeks of my life for that. I don't want to talk about it anymore. But when you find a person who does want to talk about it, and usually about half the jury will, they'll spend 2 hours or longer just telling you all the stuff they reacted to and when they changed their minds and how they argued with somebody else. The first thing they do is they're told to select a foreperson. And if you're a tall, male, Anglo, and sit at the head of the table, chances are very, very strong you'll become foreperson. Even down to the simple fact of sitting at the head of the table versus the middle of the table. So that's one thing. Then they generally go around the table, and each person, instead of instead of waiting to, as the judge would admonish, don't wait till you've deliberated together until you reach a verdict. Each person will state a verdict. And so in a short while, the entire panel knows how each person thinks, and then they start fighting, actually.
And how important is the foreman? Because I recall there was a jury that I was standing for, and I think both of the the defense and the state, it was a criminal trial, said we don't want this guy, because I had done a lot of programs about the criminal justice system in my state, and they didn't want someone who might act as the foreman or become the foreman who could influence others. So how careful is that selection of the foreman, and how important is that selection?
Well, when judges are selecting jurors, they often think, if that guy ends up in the jury, he's going to be an opinion leader and bring a lot of jurors with him, and I'm not sure what he's going to decide. Like they'll spend a lot of time figuring out, taking you as an example, and thinking, knowing what they've gleaned about from voir dire, trying to figure out what would that guy do and think, and how many people would he bring along with him, and decide we should just strike him. He's too much of a wild card. Since you've asked about jury selection, I mean most judges and attorneys will, if the judge handles voir dire, he'll say, well, what do you do for a living? And where do you live? And are you married? Those kinds of questions virtually have nothing to do with verdict. And the attorneys will say, will you promise me you'll keep an open mind and not make up your mind till you've heard all the evidence? That has nothing to do with the verdict. To have any questions, voir dire questions at all that relate to verdict, they have to be highly specific. Behavioral factors, lifestyle factors, attitudes, values, beliefs that are very close to the issues at stake in the case. Only then can you begin to have some predictive value in using questions, drawing questions that predict verdict. And the questions will differ for different gender and ethnicities.
Now, with your consulting firm, because we really didn't talk about this at the beginning of the interview, what is it that you attempt to do? Do you work on the side of the state or the defense in terms of trying to figure out what this might mean in a real trial to someone? I mean, tell us how important the role of the consultancies now have become, and how important in that process is knowing who's going to be on the jury. It's like gerrymandering. The politicians know who the voters are going to be before we get to select them. So how important is that voir dire process?
The mock trials are important because they allow you to stage a case in advance. And you can actually will have 2 or 3 different versions of trials, mini trials. And the people who hire us will staff it with attorneys who are totally familiar with the case. And we will recruit people from the local venue who match the persons who would be on the jury panel. So they show up to trial. I mean, they would basically run in a hotel ballroom, hotel meeting room. They show up to the hotel meeting room, and we first give them these very intense questionnaires with all sorts of questions about themselves, values, attitudes, lifestyle, so we can see what kinds of persons' characteristics predict voting for plaintiff or defense. And then we do a mock trial where we ask the lawyers to present their opening statement in whatever way they do, and they would normally be kind of chronological, out of narrative order, unpersuasive way. And we would write a narrative opening statement with a beginning, middle, end, moral closure that organizes the evidence. And then we would pit our opening statement against theirs, plaintiff against defense, find out what issues matter, to whom they matter, how those issues can be better addressed, and then we often do these post-trial jury interviews. So basically, we give the plaintiffs a chance to figure out the likelihood of winning or losing. And here's where I like to point out, it's not really ending up jiggering the jury. Basically, we often tell the clients, you just don't have much of a case here. You're likely to lose, and if you lose, the damages will be between, say, $50 to $75 million. And hearing that, the client may decide it's in our interest to settle.
And don't most cases, civil, perhaps as much as or more than criminal, end up where there is no jury trial in America?
Staggering statistics. It turns out that less than 0.5% of all civil trials ever filed in a year go to a jury. Less than 0.5%. That's down from numbers like 20% and 25% just a few decades ago. For criminal trials, it's similar. Less than 1% of all criminal trials filed in a year ever reach a jury. That's because criminal trials tend to plea bargain. But that's just another way of distrusting the jury. So you'll confess to a lesser crime for a lighter sentence instead of allowing the jury to possibly impose a harsh sentence. And in civil trials, they either settle or they're dismissed on summary judgment, or the whole category of trials that might have gone to jury is now handled through alternative dispute resolution, ADR, which is mediators, arbitrators, or hired private judges. For all these reasons,
yes, go on.
We're trial by jury is vanishing.
But is that a good thing? I mean, you're telling us on the one hand that these juries really are overmatched, or they're not really presented information in the way that they process it. So that's not a good thing. And oftentimes they're very arbitrary in the way they're coming out with decisions. On the other hand, I don't think you sound terribly thrilled with some of the impartiality that we brought to the system in terms of what that might yield as well. Is that correct?
When jury verdicts are mocked, like the McDonald's coffee verdict, or jurors are mocked for being ignorant, gross, incompetent, inattentive, can't handle a case, I almost always say it's not the juror's fault. It's the lawyers and judges' fault. It's the court's fault. It's the fault of a system which presents information to an organism like a human being without having any idea how the human brain processes information. So for me, the reforms in the jury system, the main one would be lawyers and attorneys begin to think like jurors, that they view the trials as a contest of narratives and not a contest of evidence. And that doesn't mean doing away with the evidence. It just means organizing it into a narrative, because the brain evolved to operate that way. So how can you not present information the way the brain expects it if you know how the brain expects it?
What about those impartial folks? You're talking about the mediators and those who are trying to be conciliatory to bring the parties together. Are they serving the process of justice terribly well? Or, oh, by the way, is justice really what we're trying to get out of all of this, or have we kind of lost that in the soup?
I think we're trying to get at justice, and I think justice is the kind of common sense standard that people hammer out when they deliberate together. I mean, justice is an abstract concept. And what appears to be just in one community and one jury may not seem just in another community and another jury. But if that's the case, then there becomes a larger national debate about what's wrong with different communities. Why do different communities view things differently? Yeah, there's pretty good data that mediators and arbitrators, everyone is biased. They may be differently biased, but they're biased. We were hired by the client to stage a big trial where we had jurors on the one hand and mediators on the other. And they were actual mediators we hired to take part in this mock trial. It was a very complicated case about a company who claimed they'd been overcharged by suppliers for 10 years, highly complicated projections of economic damages. The jurors couldn't understand it. They decided, well, I can't follow this projection of damages, but it seems to me if this company claims it's been overcharged for 10 years and they're a big company, it was up to them to find it out. I go over my checkbook and I see if I'm being overcharged for stuff. But why wouldn't this company? Whereas the arbitrators or the mediators thought, it's a pretty complicated economic case, and I don't exactly understand it, but I've done lots of these kind of cases before, and I usually understand it, and so I think I'm going to side with the company. So there were two different sets of biases, different biases, and it led to different verdicts, and it's hard to say, which one is right.
When you do look at the whole process of unanimity, and I started an earlier question about this, with America so divided today, what are the breakdowns? Is it socioeconomic? Is it political in many cases? Do some of the ruptures, red and blue, end up in the background of whatever it is they're deliberating about?
For us and in our work, we would often find it was a function of gender and ethnicity. I think I gave the example earlier, about the worldviews of old rich white guys versus the worldviews of young poor minority women, and how those different worldviews and how the different sense of vigilance and what's going to hurt you and what kind of warnings you need in advance and what kind of protections do you need in advance. They're just two clearly different worldviews. And I think it's very hard to say who's correct. I mean, the old rich white guys are correct for themselves, and the young poor minority women are correct for themselves. It means that justice is kind of a social construct dependent on something like social power that differs as a function of gender and ethnicity. You can almost stack it. So you get blacks, Hispanics, Anglos, Asians, men and women. You get 8 cells. And you can almost always predict what questions will predict verdict within each of those cells, and they're very different questions.
Does sequestration make a difference in the types of deliberations that jurors undergo, or is sequestration just so rarely used that it's not even worth a great discussion about?
I don't know any statistics on it, so I couldn't contribute much to that question.
What about opening and closing statements? As dramatized in terms of jury trials, we always see the great Perry Mason or the great whomever, and it's always so important, that opening or closing statement, and that is usually a story.
Well, it's supposed to be a story. That's where lawyers often, instead of telling a story, that's where they use their yellow pad. And they'll say, so they'll present sort of 50 points of evidence. They'll just kind of check off and say, and this witness will testify about, and this witness will testify, and this witness will testify. And jurors at that point are not really, why am I being told this? I don't even understand it. Whereas we train the lawyers who hire us to do a narrative opening statement that organizes evidence. And here's where I say that there are two types of lawyers. Often the plaintiff's lawyer is kind of a backslapping, storytelling sort of good old boy.
Mm-hmm.
With a private jet, flies in, tells a big story about the evidence, and jurors are very clear. And these people succeed by being in court all the time and gathering a few huge verdicts. Whereas the defense lawyers are often cautious, careful, smart people who want to dot all the I's, cross all the T's. They're going to want to do a lot of discovery and then hope to settle before they have to go to court. So they have very little experience with jurors and with jury trials, and they don't start off being the kind of storytelling personality in the first place. So often the people who hired us need us because of they're a certain kind of person that isn't very adept at telling stories.
And you talk about the phenomenon of the vanishing jury. Do you want to add anything to that? Because people may not have heard of that construct, though when they read your book, by the way, it's a great book, The Jury Crisis, What's Wrong with Jury Trials and How We Can Save Them. What about the vanishing jury? What more can we add to that?
I think we just can't emphasize enough that without juries, democracy suffers. Sixth and Seventh Amendments of the U.S. Constitution guarantee trial by jury. And yet, almost any contract you sign, you agree to waive your right to trial by jury and undergo binding arbitration. Democracy requires jury trial, I think, both for the justice to feel that you've been judged by a jury of your peers, and also to teach peers how to talk to each other. In our mock trials, we'll have coalitions of blacks and whites on one side and a coalition of blacks and whites on the other. And these are the kind of people probably who end up reasoning together, talking about strategy, moral issues. They probably don't have dinners together in real life.
You also try to answer whether America's trust in a trial by jury is justified or woefully misplaced. So what's your verdict?
So long as the system dumps statistics on jurors and avoids a narrative, then the system won't work very well. But my answer is, it's not the jurors, again, it's not the jurors' fault. It's the way that the jurors are treated by courts, judges, and attorneys who don't understand how the human brain works.
We're going to be ending in a moment. Any other reforms that you'd like to leave our listeners before they've read your book, though we hope they will add that to their duties as a citizen who may end up on a jury? I think it would be really instructive. Anything else that you'd like to add as a reform?
The question I get asked most often, any gathering, party, dinner, anything, is how can I get off jury duty? I always tell people, don't get off jury duty. It's ennobling. It's important to democracy. We have to do it. So I tell people, my goal would be for somebody to get a jury summons instead of cringing to say, oh, wow, I got a jury summons. How cool is that? That's the kind of reform I would like to see.
All right. Dr. Drury Sherrod. And the book is called The Jury Crisis, What's Wrong with Jury Trials and How We Can Save Them. And I think you explained in your last answer how we can save them. We've got to be a part of them. And again, I know I've gone to these jury deliberations, and I don't see a lot of people necessarily like me who end up there. I do see a lot of folks who are perhaps poor, indigent, and they end up in there, but many people waive their right or figure out a way around the system. Well, I thank you for being with us.
One final addition there is fewer peremptory strikes. Don't try to strike everybody who's educated or who might be against you. Okay.
Absolutely. Thank you so much for being with us today on America Trends.
Thank you. I've enjoyed this.
America Trends podcast is part of the MHNR Network, mhnrnetwork.com.